No, I stole it on my kid's name. No, I yes. Listen, they get up. Hey, how are you? I brought some more bags there. They're super strong.
Yeah.
Tell me your first name. Oh, okay. I don't know what. So what's your plan? You're in good shape. Oh, how much? Oh, too big of a change. I guess we could have outside.
Good morning. I'm going to call to order this public meeting of the Arapahoe County Board of County Commissioners for April 9th, 2019. To my left is Ron Carl, the county attorney. To my far right is Jolene Sanchez, the assistant clerk to the board. Ms. Sanchez, would you please call the roll?
Commissioner Conti?
Good morning.
Good morning. Commissioner Sharp?
Here.
Commissioner Holland?
Here.
Commissioner Jackson?
Here.
Commissioner Baker?
Here. Please join me in the Pledge of Allegiance. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Carl, are there any modifications to the agenda this morning?
There are no modifications to the agenda.
The commissioners have had a chance to see the agenda. Are there any questions or concerns? If not, I would entertain a motion.
I'll move to adopt the agenda as presented.
Motion made by Commissioner Conti, seconded by Commissioner Holland. All in favor?
Aye.
Any opposed or abstentions? Seeing none, that motion carries unanimously. This is the time that we've set aside for citizen comments. Citizens are invited to speak to the commissioners on non-agenda items, related items. If we have public comment under the general business items, then we'll have citizens come up to give comments on that specific item during that time. But if there are any citizens that would like to address the Board of County Commissioners, please make yourself known to me. Please come forward, and you'll have 3 minutes. Then we have a little yellow light and a little red light up here. The yellow light will come on when you have 30 seconds left.
Lovely.
And the red light will come on when you've used your timer.
Don't start yet. I'm going to split mine into 2 sections since part of it is one of the agendas, and then I have one.
Well, when we
we'll hit that one later.
We'll call the agenda item up later. Yeah.
Okay.
So this would be to address us on something that's not already on the agenda. So if you could state your name and address for the record, please.
Okay, and stop me if it is too correlated to an agenda item. My name is Kim Modisett. I'm at 3602 East Geddes Place, Centennial, Colorado.
Good morning.
Good morning. Hi, I'm here to speak on behalf of other residents that have concern about our small cell technology deployment.
Okay, yeah, that's the item that's going to be on the agenda.
That is one of the specific ordinances, but I'd like to speak at large about the topic in general, or I could couple the two as well.
Okay.
Up to you.
Go ahead. You have 3 minutes.
Okay. I'm Kim Modisett, as I discussed. I'm a 20-year aerospace engineer and project manager, and now new mom. Protecting ourselves. Being a new mom has opened my world of how we need to now protect ourselves and of the effects of our fast technology as it is today and even in the future. We are a little late to this game. However, to protect ourselves, rolling out this technology is very desirable. I want to thank personally the Mayor Pico, for traveling to Washington, D.C. to discuss concerns about the 5G deployment with Jason Crow. I also want to highlight the Douglas County Commissioners have also met with Jason Crow last week to also discuss the 5G concerns. Jason Crow, as of this morning, wonderful news, he is now supporting House Bill 530 as a co-sponsor to regain control over our local municipalities. As I mentioned, I'm a new mom. Kids specifically absorb 10 times the amount of radiation that an adult does. The FCC has some standards for a specific absorption rate. However, they are all tested on a 250-pound, 6'2" man. So we need to be able to compare apples to apples when we are rolling out this technology. We need to make sure that our 5G challenge is not lost in the legal battle, as we have many challengers that have approached the FCC. We have many FCC lawsuits going on. We have the NRCD challenging, as well as a lot of other cities and rural areas also making a stand to challenge the FCC overruling. So there are options in our trade space, and I applaud you for one of the agenda items for the work that you're bringing forward to this. It's our civic duty to understand the risks that come with 5G technology. We've taken an oath to protect our citizens. I encourage you to start learning about the new technology language and start implementing that language into some of our work that we do here. I encourage you to manage differently, especially with the permit process. Maybe hire an EMF expert to be part of the permit process especially. It's not, what red means stop. Okay, it's not just structural engineering anymore in our new technology world. It is now radiation, EMF, and EMI. Thank you very much.
Thank you very much. We appreciate it. Are there any other citizens that would like to address the Board of County Commissioners? Seeing none, the public citizen comment period is closed. We have approval of 2 minutes, 2 sets of minutes. The first one is from March 12th, 2019, and we had a full board. Are there any questions, comments?
I'll move approval.
Second.
Motion made by Commissioner Sharp, seconded by Commissioner Holland. All in favor? Aye. Any opposed or abstentions? Seeing none, that motion carries. The second set of minutes that we have are from March 19th. And at that meeting, I was absent, and Nancy Sharp, you were also absent. So are there any questions, comments, or motions?
I move approval.
Motion made by Commissioner Holland, seconded by Commissioner Jackson. All in favor?
Aye.
Abstentions?
Aye.
Aye. So with 2 abstentions, that motion does carry. Are there any questions or comments from any commissioners about the items that are on our consent agenda at this time? If not, I would entertain a motion to approve the items on the consent agenda.
So moved.
Second.
Motion made by Commissioner Conti, seconded by Commissioner Jackson. Any further discussion? Seeing none? All in favor? Aye. Any objections or abstentions? Seeing none, that motion carries unanimously. We have one general business item to be discussed today. It is just a general business item. This is case number E19-024, Design Standards for Small Cell Facilities in the Right-of-Way. Our presenter this morning will be Jason Reynolds, the current Planning Program Manager from Public Works and Development. Our attorney on this is Robert Hill, Senior Assistant County Attorney. Mr. Hill, would you please lay the foundation for us?
Yes, thank you, Mr. Chair. This is an agenda item it's a general business agenda item. It wasn't noticed as a public hearing, but I would recommend the board allow public comment prior to making a decision. So this is for a new chapter to the county infrastructure design and construction standards, and it's going to address design standards and procedure for basically approval of small cell wireless communication facilities within the public right-of-way. It only applies to facilities that are proposed for within the public right-of-way. Under the state and federal scheme for this, federal statute as well as state statute, and then FCC order interpreting federal statute, the county does not really have much discretion about these being in the right-of-way, these type facilities. They're allowed in the right-of-way. We're subject to specific requirements to let them into the right-of-way. We have the ability to consent, but that is sort of a limited consent. Our review will have to be based on standards which are in place and under the FCC order, which is also another reason we're a bit under the gun here in terms of getting these standards in place. We have to have them adopted by April 15th under the FCC order. So what you have in your packet is the first draft of the new Chapter 14 for the infrastructure design and construction standards. That version has been modified a little bit since it made it to the packet. We've had consultation with our outside legal counsel on this, and as a result came up with some modifications to what were in the original version. And I'll just go through those modifications briefly here. We clarified that these are for small cell wireless communication facilities, not for macro cell sites. We deleted a reference to personal wire service facility in section 14.2. Colorado state statutes includes these, but I think that's an error. We clarified that pre-submittal meetings are optional, and that if we do hold one, the shot clock does not start until the provider submits an application, but that's at the provider's choice. We set the shot clock review to 90 days. We revised the preferred small cell location hierarchy in section 14.2.2. We removed the strand-mounted reference because 5G installations typically are not strand-mounted. Should the technology change, strand mounting is still an option under 14.4.4b. We changed maximum antenna shroud height to 8 feet from 6 feet. We provided some flexibility in pole location along lot lines. The pole can be located within 15 feet of lot lines if necessary to avoid a utility or other conflict. And we also added a provision for undergrounding ancillary equipment such as cabinets and boxes where that equipment's not integrated into the pole, and it's under a circumstance where basically if there's a safety need to underground the equipment, or if it's an aesthetic reason to fit in the community the way everything else is in the community, so we wouldn't have a sore thumb sticking out. And with that, the board has jurisdiction to proceed with this discussion. And Jason.
Good morning, Jason.
Good morning, Mr. Chair, members of the Board of County Commissioners. There were two handouts just presented to you. One was a set of comments from AT&T, and another an email I received from Kim Motisit regarding the draft regulations, and those were previously emailed to you as well. So we are here to talk about design standards for small cellular equipment in the right-of-way, and just a brief overview of what small cell is. It is equipment that's generally smaller than 3 square feet in volume, and is going to be used to help roll out the next generation of wireless facilities that have higher bandwidth but also shorter range. And that's likely a reason why the FCC order came about, was to encourage these to be placed in the right-of-way so they could be in more places than your typical so-called, what they're called macro cell towers, the large ones that are 50, 100 feet tall. They are often located in public right-of-way, and that's a requirement both of the FCC order 18-133, requiring local jurisdictions to place these in the right-of-way. There's also a Colorado law and a section of the revised statute, section 27-27-402, which requires local jurisdictions to allow these in their right-of-way. These are some examples of small cell installations around Arapahoe County, a couple that are currently in place. One is functions as a streetlight. The other is just a pole with some wireless equipment in it. We also have some proposals for additional small cells in the right-of-way. This is a photo simulation from the Zayo group for a proposed location near an intersection. So our proposed design standards are located in the Infrastructure Design and Construction Standards Manual. They encourage co-location on existing utility poles, existing streetlights or replacement of streetlights, and existing traffic signals with appropriate engineering analysis to make sure that the things that they place on our traffic signals don't interfere with the operation of those traffic signals or the structural integrity. The proposed standards would also allow new standalone poles in the right-of-way. So for attachment to existing poles, the antenna is required to be shrouded, and it may stick up about 10 feet, up to 10 feet above the existing pole, and must receive that pole owner's permission. So whether it's XL Energy, IREA, or us, they would need to receive the pole owner's permission. They can also integrate streetlights where necessary, as deemed by engineering analysis. Not every place along the street needs a streetlight. It would be likely to occur at, say, intersections or maybe the entrances to apartment complexes. They could also do a standalone installation, as we saw in an earlier slide. The standalone installations are required to be 600 feet separated. That doesn't have to be separated from an existing pole. For example, you saw that photo simulation, Zayo was placing one near an intersection, and it was definitely not 600 feet from existing traffic signal standards. The regulations include an administrative waiver provision where that 600 feet could be adjusted due to technical necessity or safety reasons. The poles would have to meet a standardized design, which is outlined in the standards, or meet the pole design in the area. For example, Copperleaf has a different standard than you'll see sometimes on county poles. They have street lights that resemble old sort of carriage house style street lights. The standards also set a maximum height in residential areas of 30 feet so that these aren't really tall installations in neighborhoods with houses that are in the 25 to 35 foot height range, 40 feet in non-residential areas. We did receive comments from AT&T and like to address probably what their biggest concern is about co-location, and the standards when you're installing a new pole would require co-location, and AT&T asked that we add to the extent technically feasible. In consultation with our attorney, we believe that can be addressed through the administrative waiver process. I will offer that this is our first hopeful adoption of these regulations. We are going to follow up and ensure that these dovetail nicely with our wireless communication facilities regulations that are in the Land Development Code. That will need to be revised to accommodate these as well. The issue with if we mandate co-location, the feedback I got was we may end up with much taller poles because you have to have antennas separated due to radio frequency interference, and that would not necessarily be a desirable outcome, which is why we have that administrative waiver process. We also received comments from a resident on public notice. Our current commercial mobile radio service code, which is a fancy word for cell tower, does require notice to affected parties and nearby residents and does provide for an appeal process. And that's something we'll need to clarify with how that interacts with these small cell provisions. And another request was that applicants demonstrate that they're in compliance with FCC standards, which we can and will address through a submittal requirement that will accompany anything we hand out regarding small cells in the right-of-way. We do want to make sure that the applicants are confirming through radio frequency engineer that the proposed installation does indeed meet the FCC requirements for small cells. And staff's recommendation is that we do adopt these design standards for small cell facilities in the right-of-way. I also have Kathy Valencia with our Engineering Services Division who can address some of the comments that we received regarding AASHTO and engineering standards and site triangles. And we also have Ken Fellman, who is our outside legal counsel, who can address questions related to the FCC order and small cell regulations generally, and our sort of the limits of our authority in regards to radio frequency emissions. It was mentioned that Congressman is sponsoring a bill that would give us local authority when it comes to radio frequency and small cells or even cellular installations. It's one of those times where we have to encourage people to lobby their member of Congress because it's set at the federal level. And with that, I'll answer any questions, or I can invite Kathy up to talk about.
We have a couple of questions for you first. Commissioner Jackson and then Commissioner Sharp.
Yeah, this is so highly technical. I don't really, in some of the issues, I don't know enough to ask good questions, but I will tell you that the materials you supplied us made me very conscious of where telephone poles are. So as I was driving today, I was saying, oh yeah, it's at the edge of okay. So anyway, that aside, there is something in here that said something about $20,000 for bond and license. And it didn't break it out. So I was wondering if that's, and then I noticed also in one of these supporting documents, someone also mentioned it. So can you separate that out for me?
Not easy. I'll invite either Bob or Kathy to.
I was going to say the $20,000 bond, that's a provision for a street cut and right-of-way permit under our infrastructure and design standards. So it's a standard bond that's in place. Someone, whether it's a telephone company, a sewer and water company, they need to cut or reroute traffic, do any kind of work within the right-of-way. It's a permit for access into the right-of-way. The bond is just in place. They don't need a bond for each incident. If they're going to be working with the right-of-way, they can come in, get a bond. They can get a 1-year permit, which allows access for that year in the right-of-way under the existing bond, which just guarantees that, maybe there's an accident, they failed to do something properly, or they cut the street, don't replace it properly, it starts settling, the county has to incur costs to repair that. That's what that bond covers.
Thank you. One more?
Yes, please.
Thank you. Okay, this one's a little out there. So I have read that 5G, there may be some difficulties with it because of using Chinese software, which is this a conspiracy theory, or is this have some truth to it, that some of the software could potentially have some, I don't know what to call it, malware or some kind of problematic software in it, and that there was some kind of hesitancy of rolling that out? Is that conspiracy theory stuff, or is that real, or do you have somebody here who could address that?
I'm not sure I'm knowledgeable on that topic.
You have a lifeline is raising his hand.
Well,
Yeah.
but can we come back to that, because I want to let Commissioner Sharp ask Jason his question. So we'll put that on the parking lot.
Okay.
And then we'll come back to it. Yes.
So my question was, I'm looking at, let's see, I have to go all the way back. Let me just go on the page. 14-6, it says at the top, pole separation at least 600 feet. But then in the engineering review, F says new freestanding small cell wireless poles will not be located within 300 feet radially from existing freestanding. So what's the difference between the 300 and the 600?
That 3 should be a 6.
Okay.
F, paragraph F.
So F should be 600 feet.
Yes.
Radially. Okay. All right. I did read. I told Ron I read this very thoroughly last night, and my question was also on the 20,000, on whether that was enough really for potentially for street cuts. That doesn't seem like very much money if they have a street cut or something isn't repaired.
That may be a future amendment to the infrastructure and design standards.
Okay. I think those were, and then there were some questions that we got this morning here on the dais that I think had some questions specifically on the application process and all of that. So we're responding to all of those from wirelesspolicies.com. This Liz Walker.
Right.
Is that?
Yeah, and that's, at least in terms of the application process, some of that can be addressed through checklists and forms that we provide to applicants.
Okay.
They're not finalized at this point, but we want to make the process very clear for those who are wanting to apply. And And
Right.
that has two functions. One is that it's good public service and communication. Two is also that there is that 90-day shot clock. So we want to ensure that we have applications that meet all of our requirements when they come in the door so we can respond quickly to them.
And addressing Ms. Modest's, if I pronounce that correctly, concerns. As I read through this, these are not going to be allowed on buildings. These are street, and there are other questions that she had as well, concerns, but this is only right of way. It's not some of the issues we had with some of these towers on elementary schools and that kind of thing. Is that correct?
That's correct. These are strictly for small cell facilities, 3 cubic feet or less within the public right-of-way. Now, applicants can choose to locate these facilities on private property, but they would have to negotiate a lease agreement with the private property owner. So they have a pretty strong incentive to locate in the right-of-way where it's much cheaper to be.
Okay. So if they could do that, but they would have to go to a school district, for example, or child care center, because I know a lot of people are concerned about young children, but they would have to negotiate that. That has nothing to do with our approval?
It has nothing to do with the approval of the standards.
Because we're looking at the right-of-way
Right. But
issues. Okay,
those-
that's separate approval through those private organizations or
right.
quasi-private.
And through our existing commercial mobile radio service regulations, which do allow those types of facilities to be located on buildings, whether it's an office building or a school.
Okay.
And those have a set of criteria and a set of procedures attached to them. But as I mentioned earlier, we do need to look at those regulations along after the hopeful adoption of these to make sure that they work together.
Yeah, I think that would be a good thing, and I think as what you said is that it is financially more beneficial to be located in the right of way, and so maybe we can talk, and I don't know if Mr. Feldman can talk about the radio waves and some of those kinds of things, because I know there's studies both ways. Some that say, no, there's not an issue, and some that say it is. So,
Commissioner Conti has a question.
And maybe my question needs to be deferred to another.
Well, why don't we have them come forward both?
Absolutely.
First, we'll start with Ms. Valencia, Kathy Valencia, if you want to come forward. And I don't know if you have prepared comments. Okay, great.
Good morning, Sal.
Good morning.
I'm Kathleen Valencia with Engineering Services Division. So just one of the questions that Wireless Policy Group had was on the clear zone analysis and where those regulations come from.
Clear zone? Is that what you said?
Clear zone analysis? Yes, so that's one of our requirements to process the application. So basically that's saying that this is going to be an obstruction in the right-of-way, and we want to make sure it's in a safe location. And that's from the AASHTO Roadside Design Guide, which is American Association of State Highway and Transportation Officials. So that answers that question. We require that for all small cells in the right-of-way. And also the question was on site triangles and how is that defined? And that's in our infrastructure design and construction standards as well. And that's a 30-foot to 50-foot, depending on roadway classification. At the intersection, so it's from the right-of-way line, that distance. So basically we want that to stay clear of any obstructions for the traveling public. And finally for permitting and inspection, so each location will have a master license agreement, so that's how they get their license that we already have prepared. And let's see. And then just to go along with that $20,000 bond, as Bob said, that's per company, and it lasts for 1 year. So we have, when they apply for the street cut right-of-way use permit, they have to be bonded. And I think those are my only engineering questions.
Commissioner Jackson.
So it's $20,000 per company, not $20,000 per installation of one of these devices.
Correct.
Okay. And then to Commissioner Sharp's question, in the past we have found that to be an adequate bond.
Yeah, I can't really speak to that.
Okay, Commissioner Conti had a question. I don't know if it's been answered.
I just wanted someone, if possible, to address the radiation issues that Commissioner Sharp had kind of alluded to, I
think we're going to get that eventually. Commissioner Holman.
This is really kind of directed to both in our legal counsel. If a bond number is set and the damages that are incurred significantly exceed that bond, we still have legal redress. Is that correct?
That's correct.
Okay, thank you.
Thank you. So let's hear from our outside counsel first. May be able to answer the questions. It sounds like there's radiation questions. So if you could come forward and just state your name, if you could, for the record, and your firm.
Good morning, Mr. Chairman, Commissioners. My name is Ken Fellman. I'm with the law firm of Kissinger and Fellman. I've been working with your staff on these design guidelines. If I could, let me address a few issues. I will get to the radiation issue, I promise. It may be helpful just for you and for the public to know, why are we doing this now and why are we just talking about design guidelines? We had a new state law that was passed in 2017. Commissioner Conti probably is very well aware of that. You were okay, sorry. In any event, it dealt with facilities, small cell facilities in the rights of way. And many local governments got to work on amending their codes or looking at their codes and preparing for that. And then last September, the FCC adopted a rule dealing with the same issue, in which they started right at the beginning by mentioning that there were 20 state laws at the time that dealt with small cells and said, we are preempting almost none of any of the provisions of those state laws in this order. And in the next 100 pages of the order, they never told us exactly what they were preempting. And indeed, there are 5 or 6 things, and substantive things, in the FCC rule that conflict with Colorado statute. For the most part, we have been advising our local government's clients to comply with the state law, even though it conflicts with the federal statute, in part because this state law was negotiated with a lot of help from the wireless industry. It was a collaboration between local governments and the industry. The sponsors of the bill made sure that we did that, and I think there's been a commitment made on both sides to make that work. The FCC order is being challenged in federal court. Arapahoe County is a member of the Colorado Communications and Utility Alliance, which is one of the many local government parties that are challenging that order, and it may very well be that the FCC order is not going to stand. But one part of the FCC order said that communities can still regulate aesthetics if you have design guidelines or design standards that are reasonable, that are applied equally to similar infrastructure, and that are published. And the deadline for having those standards in place and published is April 15th. And that's why we are here today, so that we will have these in effect. Just like the necessary update that's going to be coming for the broader commercial mobile radio regulations, I would tell you these are very good design guidelines, but we're going to have to change them. These small cells in the rights of way are new things. We don't know how it's going to work when we actually get to deployment. We have a whole bunch of companies applying for these sites, and I will tell you that whether on any board of commissioners or city councils that I appear in front of, I say, this is 95% really good. But we're going to see some things once we start seeing implementation of these small cells in the rights of way where we're going to say, you know, it could work better if we change this or change that. So staff will be back at some point to talk about how we improve these or how we make it work better. But that's why we're here now. So Jason mentioned that these are generally 3 cubic feet under the definition of the facilities. It's the antennas are 3 cubic feet. All of the other equipment that goes with a small cell under state law can total 17 cubic feet. And then there are exceptions that say things like generators and meters and are not included in that. So if you think about the antennas on the pole, and they have to have these remote radio boxes, and they need an electrical meter, 17 cubic feet is actually somewhat substantive. And one of the areas where our state law conflicts with federal laws, the FCC rule says 28 cubic feet. So did they intend to preempt our state law or not? They didn't say. 28 cubic feet is really big. If you Google images, 28 cubic feet, you will see ads for large refrigerator freezers. That's about 28 cubic feet. So anyway, now you have a better picture of the size. To the Chinese equipment issue, Commissioner, I have heard a little bit about it, not so much about the malware, but just our federal government is pushing this 5G deployment so fast. There's all these arguments. We're losing the race to 5G with China. When I talk to consumers about 5G, everybody wants faster internet. They want better service in their homes and businesses, and they want them at more reasonable prices. I don't think anybody really cares about the 5G race with China. I think people care about good service and better prices. And I think that's what our goal is. I was talking a little bit to Commissioner Holland before the start of the meeting this morning. The industry wants to get these things up as quickly as possible and efficiently as possible, and I certainly respect that. We want the same thing because we want better service in our communities as local governments. I'm using the collective we, but we want to do it in a way that protects the aesthetic integrity and the health and safety of our communities. So we need to balance that, and that's what these design guidelines are intended to address. On the Chinese equipment, what I've heard is that we don't have American manufacturers who have agreed to or have plans to widely manufacture some of the same stuff. So I have not heard so much the malware, and I don't know if that's a conspiracy theory or not, but I've heard as a policy matter of, do we want to spend millions and millions of dollars with Chinese manufacturers, or do we want to wait until some of the American manufacturers have this in place? But at the end of the day, our federal government, those at the FCC who are pushing this thing, that we've got to get this done so quickly, they don't seem receptive to that issue. So I think it's a fair question to ask, but unfortunately I don't have an answer for you that's definitive at this time. To the RF issues. Some of you know I'm a former local elected official, so I have been dealing with this both as an advisor to local governments, but also as an elected official for many, many years. Back when the 96 Act was passed and we started getting all the big cell towers, and the issue of radio frequency emissions was up then. I have served periodically and am currently serving as on an advisory committee to the FCC called the Intergovernmental Advisory Committee. We were talking about these issues back in the early 2000s, and we're talking about them now. This is an area where Congress has specifically delegated authority to set health standards to the federal government, to the FCC. And the FCC has published, as you heard during public comment, standards for radio frequency emissions and the limit to which exposure is permitted, and over that limit it would be a violation. The FCC has not updated those standards in years. The standards don't easily fit with some of the frequencies, not all, but some of the frequencies that the 5G technology will use and the lower heights that these facilities will be sited at when they're put in the right-of-way. And the Federal Communications Commission has had a docket open for over 5 years to update the health standards for RF emissions. And they're not moving on it. And I know our committee in the past worked with the FCC, this advisory committee, to come up with a guideline for local elected officials dealing with radio frequency emissions. It was published in 2000. It's still actually pretty good information, but it needs to be updated. And this current FCC, no matter who asks them to please move forward and finish this docket and give us a tool in local government that we can work with to know what the updated standards are, what's safe and what's not, they just won't move on it. And there is case law, including federal case law in the 10th Circuit, which Colorado is a part of, that makes it abundantly clear that local governments have no authority to regulate in this area. We can require, and I think it was Jason who mentioned that we will require in applications that applicants provide some letter from a radio frequency engineer that demonstrates that the facility, once operational, will be in accordance with FCC standards. And we have to deal with the standards we have now, even if it may not fit specifically with these technologies. We don't have the authority to require periodic testing. If there's reason to believe that there might be a problem, certainly any local government could do the testing, could hire a radio frequency engineer to go out and do some tests. And if there's information that would suggest there might be a violation, the remedy is to go out to the FCC field office at the Federal Center and make a complaint and let the FCC handle it. The case law is very clear that local governments do not have the authority to say, if we find you're exceeding the standards, we can pull the plug and shut down your facility. I would love it if we did. I used to try to put that stuff in the ordinances that I wrote, and I tried to get it into the ordinance when I was mayor of Arvada, and eventually I just was convinced that the law is not on my side on this one, and we're stuck. The best that we can do, I would tell you, I've read some of these studies too that suggest that it's okay, and some of the studies that suggest that maybe there's a health hazard here. And the FCC has a duty to give us the kind of information that Congress says they're required to give us, and I don't think they've done a very good job in doing that. So to the extent that you are interacting with your members of Congress, I would suggest you encourage them to put pressure on the FCC because they do have oversight responsibility. And we have 2 members in our delegation who serve on the Commerce Committees in their respective body and on the telecom subcommittees, and that's Congresswoman DeGette and Senator Gardner. And they are the 2 that have the, I think, most ability to help us put pressure on the FCC to get us the information that you need to do a better job of protecting your communities. And I think it goes without saying that Congress or Senator Gardner has a lot of incentive to be listening to us, especially this year and next year. So I would encourage you to talk to your delegation about those issues. I'm happy to answer any questions that you have about these issues or any other ones.
Commissioner Conti first, then Commissioner Holman.
Thank you, Mr. Chair. Speaking of the law not being on our side, okay, if Jason Crow is talking about sponsoring this bill to give local governments more control, how could this be changing in the future, and how quick would you see that this could take effect, that it might impact what we're doing here today?
I don't have a lot of confidence that the United States Congress is going to fix anything for us quickly. The bill that was referenced, it's actually one of the shortest pieces of legislation I've ever seen. It's 1 paragraph, and it would overturn the FCC rules that were adopted last September. It would not give you any more authority than you currently have, which is almost none, on the RF issues. It simply would overturn the FCC's small cell bill. It was introduced by Congressman Eshoo from California. It has a number of sponsors. I was actually in Washington a week and a half ago, meeting mostly at the FCC, but we had 2 meetings on the Hill, one with Chairman Pallone's office, and he's the chairman of the House Commerce Committee, which means he gets to say when this thing has a hearing. And we hope it's going to get a hearing sometime soon, but they were real open with us that a bill without bipartisan support may have trouble going forward, even in a Democratic House. And there's a companion bill that I hear is about to be introduced in the Senate by Senator Feinstein. It would be great if Senator Gardner would support that and help it move forward. I think if we get a little bit of bipartisan support for this kind of legislation, it would have a chance. Right now, even if it got through the House, I think we'd have a hard time in the Senate. But it would certainly put us in a position that we're sort of taking the position we're in now, which is we're going to comply with the state law as best as we can. It would certainly take all these conflicts away. For example, the FCC gives us a 60-day shot clock to act. Our state law gives us a 90-day shot clock to act. It would make it easier if we got rid of those federal rules so we knew there were no conflicts.
If I could. Yes. Okay. And so if we, obviously when our staff is talking about the fact that we really, and you're confirming that we really do not have a choice in whether or not we allow this and approve this. And obviously there's difference. Is that just does the difference come? There are people who have a differing opinion. So does that differing opinion come from simply reading the FCC rules and not going all the way back to look at the case laws that may have been established in precedent also subsequent to those?
Are you referring to the radio frequency emission issues in particular as far as our authority, or more generally for all of our authority for citing these things in the rights of way?
Citing these things in the right of way, what we're dealing with today.
Right. So, we have a state law that has not been challenged in court, but it's been in operation now for 1.5 years, almost 2 years. And while I personally didn't think we needed it, it seems to be working okay. The FCC rules, there's a lot of case law that suggests that the FCC got it wrong, and there's some case law that suggests that maybe the FCC got it right. I don't want to get too far in the weeds, so please cut me off if I'm getting there. But one of the foundational issues in this FCC order is the federal law says our local regulations cannot prohibit or have the effect of prohibiting the ability of these companies to provide service. What does it mean, have the effect of prohibiting? There are some federal circuits that have said it's a very loose standard, and theoretically it might be more expensive for the company to deploy if you tell them to do it this way than that way. That's an effective prohibition and therefore a violation of federal law. The Ninth Circuit has a decision, and actually it's an en banc decision, so every judge in the Ninth Circuit that ruled no, an effective prohibition, it has to be a real prohibition. The company has to be able to show in court that the local regulation effectively prohibits them from being able to provide service in that location. The FCC, in their rule, took the Morgan's interpretation and basically said if it makes it inconvenient for these companies, if it costs them a little bit more money, there's a presumption that you're violating federal law. Well, the case is in the Ninth Circuit, and one of the reasons I'm a little bit confident about our position in this case is that for the Ninth Circuit to affirm the FCC rules, they would have to overturn a decision in their own circuit that was an en banc decision of every judge on their bench. So I'm not sure the FCC rules are going to look the way they look now when we get done with this court case. And I think that decision will come quicker than any formal final action from Congress on the legislation.
Commissioner Holden.
Thank you, Mr. Chairman. Mr. Feldman, I want to thank you for the hard work that you've given our staff in understanding this complicated and scientifically difficult process. What I'm heartened by is the fact that you understand and your recommendations reflect that this is a ongoing iterative process and there will be changes. And that may be reflected in both what happens in Congress as well as what happens in the courts. Can you kind of comment a little bit about how long you think this process will go, and what steps should we take as a county to ensure that one of the primary issues that seems to be emerging is the health concerns?
I think there's three levels. So the way this is going to go in Congress, I just don't have a lot of confidence that this Congress is going to address this issue in a way that's helpful. There was also a draft of a bill circulating that would have made it, again, would have preempted more local control in the way we deal with these things. And it was circulating through the staff in the Senate Commerce Committee, and I know that Sam Mamet from the Colorado Municipal League had a long talk with Senator Gardner and his staff about it. And to his credit, Senator Gardner did not sign on that bill because it would have been terrible for local governments. But so I just don't know which way Congress is going to go. I do think we're going to get an answer from the courts about these FCC rules, hopefully by the fall. We actually have a case management conference next Wednesday with the magistrate judge in San Francisco, and that's important because there's a couple of procedural issues that are pending. I won't get into the details. There's a briefing schedule. We don't know what the briefing schedule is going to be in all of the local governments, and there are probably 40 or 50 or 60 of them represented by multiple law firms. We have a group of Colorado communities and Washington State communities, Seattle and King County and Tacoma, and a few others. But we expect that the court will set a briefing schedule. We're asking for an expedited briefing and oral argument schedule because we need an answer on these things because, as you say, it's more up in the air until we know what the courts are going to do. So I would hope that we get this case briefed over the summer and we have oral argument by the late summer and we have a decision before the end of the year. And I think that will happen before Congress does anything. But regardless of those issues on the federal level, even if those things didn't exist and we were just dealing with the state law as it is, the design guidelines are a good idea. We do have the authority. We have to let these things in the right of way, but we have the ability under local police powers, which is preserved in our state law, to determine what do we need to impose from aesthetic standpoints to protect the community character. What do we need to do from a public safety standpoint to decide where equipment might be a danger if it's above ground next to a pole and it needs to be undergrounded because kids ride their bike and it's a narrow intersection or whatever it might be. We have the ability to have separation requirements between these poles to try to avoid pole clutter as much as we can. We have the ability to adopt these regulations that encourage going on existing vertical infrastructure like streetlights and traffic signals where appropriate. So all of those things you do under both your main CMRS regulations and now these design standards will add a new layer of information for the industry of what's approved. We were talking with the AT&T folks who were here before the meeting that, they've got a couple of pole designs that they think look pretty good and they've used them in other communities. And, we said, why don't we talk with staff before you even file an application? If you can come up with 3 or 4 of them that staff thinks these would look okay in Arapahoe County, then every time you come in for an application, we're going to speed up the process because we know we picked one of these poles that have already been approved. So these design guidelines, while we're doing them because we have this FCC order that says you can't regulate aesthetics if you don't have something in place by April 15th that's published, are actually, I think, a good policy idea even if we didn't have that mandate from the feds because it gives the industry more knowledge in writing of what the rules are and how they're going to be treated when they file an application. 5G, I think, is coming. It does require densification of networks, which means more sites at lower heights. And as one of you, I think it was Commissioner Sharp, mentioned that, because these companies don't have to pay to use the rights of way, it's much less expensive for them than to lease space on the side of somebody's building to put their antennas. Those antennas on buildings and regular cell towers will still be here. They're not going away. This is just a new piece of what the new wireless networks are going to look like. Right. I wish I could give you a better answer on the health issues. I would love to see whether it's the FCC or some other authority that might be given to states or local governments to be able to address these issues. But right now, we are stuck. And like I said, I've tried to get as close to the line as I can when I write ordinances and give local governments authority to regulate on RF issues. But the language in the federal statute is very, very clear that local governments have no authority to decide whether to approve or deny a site based upon the health effects of radio frequency emissions. If it's in compliance with the current FCC standards, we absolutely cannot make a decision based upon that, and it will, in my opinion, always be overturned in court if we do. So until Congress changes the law, we are stuck on that issue, and it's a real issue, I think, that are these safe or are these not safe? I'm not an expert on the science of it. I've read enough to think it's probably safe, but I'm a little concerned that the FCC has been stalling on this. So I think we just have to do the best we can until we get new information from the FCC.
Just as a follow-up, Mr. Phillip, I think what's important, and I think it's important that I know the commissioners support this to a degree, and that is that we want to provide certainty in the process, both for industry and both for our constituents. We have the same dilemma with the oil and gas industry. We can control the site, but we can't control the permitting. So it's a very frustrating and difficult process to be able to balance. And I appreciate what you've brought here in terms of technology and your legal assessment and helping us hopefully meet the April 15th deadline.
Commissioner Sharp.
It's really nice to see you.
Same here.
Many years.
Yes.
And, really appreciate it.
And if I can just deviate for a second, we're getting a train in Arvada at 2.5 years of moving through with no people on it. So thank you for your help in the early days of getting that in place.
Well, it's been nice to work with you, and I'm really glad that on this particular issue that you have really been a help to all of our local communities with the legal side of what we can do and can't do. It is frustrating to not be able to have that control, more local control in this area. But I do think it's really important to put the standards together, at least design standards, and get as far as we can so that we can do as much as we can, knowing that we are going to have to modify these in the future. So my question is, in the metro area, have any of these providers started to put these small cell equipment in already? I mean, are we going to start seeing that pretty quickly?
Yep. It's popping up in different places. If you drive on Alameda in Denver, kind of through Lowry, you'll see a bunch of standalone poles. I think those are Verizon poles. They were put up at a time before XL would allow them to go on streetlights. XL has now changed its policy, and I know that XL has agreements with most of the carriers to basically take down a streetlight and put up a new one that will be a little bit wider and can accommodate small cells, which are great because that's not a new pole in the right of way. So I haven't seen a lot of it, but I've seen some of it because AT&T was most active compared to all the other companies in commenting on the regulations here. I talked to their representative and was told this morning that, there's a couple of sites in Arapahoe County that they want to apply for. So, and they've got a couple of sites up in Aurora and in Boulder. So they're starting to come in. What some of these companies are doing as well is, we're talking about 5G in the future. And 5G is not really being rolled out in a lot of places yet. There's some test markets. And again, there's no manufacturer who is doing mass manufacturing of 5G equipment. But a lot of these small cell sites that are being built now are to improve coverage for 4G, which is not going to go away when we get 5G. It's just like, when we got high definition television, you still have people who watch standard definition television. So you're going to need a phone that will be 5G capable. So even when 5G comes up, you'll still be using 4G networks. And as you know, from driving around the metro area, even in the metro area, we have places where you wonder why your coverage is going out. It doesn't matter who your carrier is. I know in my discussions with Verizon, they're putting up poles that have space for a 4G antenna, which they're putting in now, and then additional space on top of it for a 5G antenna when they get to the point where they're going to start deploying the 5G networks. So we're starting to see it trickle in, and I know from at least one company, based on a conversation this morning, there's two that they're going to look forward to applying for shortly in Arapahoe County.
But it will, if I could, but it will cause consumers to upgrade. I know that's not what we're really talking about, but it will cause consumers to upgrade equipment, phones and equipment in their homes and things like that.
From what I've been told by engineers, yes, you will have to have a phone that's 5G capable. Is that right? These are the AT&T folks. I don't. Okay, we think so.
Sounds like probably.
Yes.
Most likely. Yeah. Anyway, thank you very much. Appreciate you being here.
I had one question, then I'll get to you. What are other I understand this deadline of April 15th is a federal deadline. It's also the deadline for taxes. I think that's probably significant. But my question is, what are other jurisdictions doing, and has any jurisdiction decided, we don't care what the federal deadline is? More or less, they're saying we're a sanctuary county or something for this particular mandate from the federal government, I guess I could say. Just give me an idea of what other jurisdictions are doing.
I'm going to speak mostly in metro, suburban, and urban areas. I'm the county attorney in Yuma County.
Okay.
Right? They're not doing anything, but nobody's shown any interest in putting up a site in Yuma County right now. I think, and if they did, I think they'd be welcomed with open arms. I got a sheriff who uses 3 different cell phones because at any given part of the county he's in, 2 of them don't work. In the metro area, communities are scrambling to get something in place. Now, some communities actually, a year or so ago, when they updated their code in the state law, put their design standards either in their codes or when they updated their code to implement this 2017 state legislation, their codes give authority to their staff to adopt administrative regulations. And what a lot of communities are also doing is when they sign license agreements with the wireless companies too, which is the authority to give them access to be in the right of way, they put the design standards as an exhibit to those license agreements. While I was sitting in your meeting this morning during Jason's presentation, I got an email message from a city on the northwest side of the metro area that I was copied on, that one planner sent to everybody on city staff and said, here's our design guidelines. Sorry for the short turnaround. Please get back to me by Thursday because we've got to approve them on Monday night. So people are scrambling, and I'm hearing this from my colleagues all over the country. I think, and I've talked to a number of county attorneys and city attorneys, there's a legal theory called the pending ordinance doctrine, which basically says if you're working on an ordinance and you've got something drafted and you're talking about it and it's not quite done yet, you can still enforce it. And so my personal feeling is for communities that are working on this, if they don't feel comfortable saying final approval okay, but they've got something that they're working on, we're probably okay. I've also heard in other states of companies telling cities, you better have something in place because we're dumping 50 applications on you on April 16th, and if you try to charge us more than the FCC says for our permit fee, we're going to sue you. I have not heard that from any company, any place in Colorado, and I think part of it is because we established more of a collaborative relationship when we negotiated the state legislation a year and a half ago. So I think most communities are scrambling to get something in place. Some have already done it. Some will not have it done by next week. But for the most part, folks are focused on that date and getting something in writing and something in place.
Thank you. Commissioner Conti?
Thank you. And I don't know I think you're going to be comfortable answering this, but if not, we can go to staff as well. I'm reading in 14.3 the design standards, and particularly the second paragraph where it talks about for small cell facilities attached to existing structures, the facility can increase the existing structure height by up to 10 feet. And I'm noting the permissive language can increase, but certainly no mandate that they must increase. What would be the advantage or disadvantage of the height location as far as the transmitting ability of the small cell equipment?
My understanding of how these networks work is that it depends. It's site specific, and I have seen designs for some facilities that are 22 feet, 23 feet, 28 feet, some in the 30s, and some in the low to mid 40s. If you have a street light that's 25 feet high, and the design that you're going to use is going to put a canister with the antennas in it on the top of that streetlight. That's why we've got the can go up 10 feet, because we wanted to provide some flexibility and give the industry some room to do that. And one of the things that we heard is that they need, sometimes they'll stack two antennas, one on top of the other, and we didn't want to say whatever the height of the pole is, you can't go above that pole, because some of the designs you saw, you have to go above the pole, but they still, again, by comparison, look okay. So that was a policy decision to allow that, and it's going to depend on each company's network and what they need at that location.
So just to follow up, so the signal can sometimes work better at a higher location?
There's a range, I think, between the 20-some feet and up to 50 feet. What I have heard from a couple of the companies at a public hearing I was doing in Washington State a couple of months ago, they said, these things really don't work very well above 50 feet.
Okay, but the opportunity to move it below 10 feet, obviously we talked about the fact that they could be, impact sight lines. Certainly they would be much more visible and possibly visibly objective to passersby and so forth. Not to mention much more subject to tampering.
But the antennas themselves, I don't think the technology exists today where they're going to be anywhere near 10 feet or 15 feet. I don't think they would cover even the minimal amount of area that the companies need to make their networks work. Now, I have actually heard that there's some kind of design being studied right now that would allow these things to be put underground to send the signal through the ground for these. I don't know if that's coming in 2 years or 5 years or 12 years, but we don't know what the future is going to bring. What I understand now, though, is that they've got to be at least 20 some feet or higher. The other thing is if you put them at 10 feet, whatever the FCC emission standards are now, right now, I was talking to an engineer the other day who is an expert in this area, because these companies have to put warning signs on the pole that says, if you get closer than this, you are in a danger zone. And that's to give warning both to maintenance workers who might be replacing a street light bulb, to know that you got to get the company to turn off their antenna before you go up there and change the street light. It's about 3 feet from the antenna where you get within whatever the zone is that the FCC says is too high. So if you put and that's one of the questions in these studies right now about, is it safe or is it not safe? Because if it's at 30 feet and the radiation is coming out and it dissipates as it comes down to the ground, does that happen in a way that it's safe for the people who are walking on the ground within 10 feet of that pole? You bring that antenna down to 10 feet of height, now it's coming right out at people who are walking on the sidewalk below it. And I think then there'd be a huge concern about safety, even under the current FCC emissions.
That's why I'm kind of wondering, does this need to be elevated, or do we need to, as opposed to being so permissive, does it need to be?
The problem on the technical side of it is that they have a right under state law to locate their networks in. Okay. The companies have the right to be in the right of way, and we really don't have the right to manage their networks. So if a company says we need this site at 25 feet or we need this site at 30 feet, we can ask for their engineering information that dictates that. We can hire our own outside engineer to look at it and say, okay, we agree with you, you do need that, or no, you don't. Change the design of it because we think it'll look better if you do it differently. But it's in the first instance going to be up to the company to say, to make this work as effectively as we need it, we need to be at 25 feet or we need to be at 38 feet. It's just going to depend on what their own network looks like and what they need at that particular site.
Yeah, I think everybody would be a little bit more comfortable from a health and welfare standpoint if they were higher rather than lower. And that's why I'm wondering if we, maybe ought to be a little bit more prescriptive in no lower than.
We don't currently have a no lower than section in here. We do have a maximum height of 30 feet in residential and 40 feet in non-residential, but beyond that, that's what's...
And as far as a minimum?
We don't have a minimum in here.
Yeah, I'm wondering, would we have the ability to enact such a minimum?
The problem is if you're enacting a minimum because we want to protect the public health and safety from radio frequency emissions, it would be in direct conflict with the wording of the federal statute, which says you cannot make any decision about siting, no decision related to your land use authority based on the health effects of radio frequency emissions. It's pretty black and white in the statutory language, unfortunately.
So it's the delusion of local government control, yes.
Right. We can make these requirements based on aesthetics, but we can't make them based on health effects of radio frequency emissions. And it's interesting that you bring that up because most communities are saying we don't want them taller. Now, I think we're going to start hearing more and more from the public about these concerns about health effects, but in the communities that did this 9 months ago and changed their codes, they were more concerned with the aesthetic. How's it going to look if we've got 45-foot poles in residential neighborhoods where the current streetlights are 22 feet? Or in Greenwood Village where we don't even have streetlight poles in many neighborhoods, right? So there's concern about that. I think Aspen has something in their city charter that if you want to be higher than 25 feet, you have to go to a vote. That's probably preempted under federal law, but they're enforcing their charter until somebody in a black robe tells them otherwise. Everybody's got a little bit of a different view as to what works best in their community.
Any additional questions?
Thank you. You've been most enlightening.
Yes. That's very good. Jason, do you want to come back up real quick? Anything else to add?
No, thank you for all the questions, and I think this is a great first step to meet the FCC deadline of April 15th, and it does set some aesthetic standards, and that's sort of the main purpose of this. And as mentioned on the slide, the staff recommendation is to adopt design standards for small cell facilities in the right-of-way.
I wanted to say, this didn't go before the Planning Commission?
That is correct. It did not.
And have we coordinated with Tri-County Health Department at all?
We did not refer this to them.
Okay. Thank you. If there are no further questions, this is not a public hearing. We're not required to take public comment, but I do want to be fair, and so I'm going to open public comment. If there are any citizens here that would like to address the Board of County Commissioners on this issue, again, the 3-minute rule applies, and we have our lights up here that will signify when 30 seconds is left and when you've used your time. So we need you to state your name and address for the record.
Okay. Kim Modis at 3602 East Geddes Place. Could I please request on something only citizen here a little longer time?
I'm not sure that you're the only citizen here that will be able to comment, but we require the 3 minutes.
Okay. I'd like to bring to your attention an FCC law that is being proposed, 7236. It is trying to remove all liability from the FCC with regards to safety concerns. So I have concern for the city if you will now be liable for any safety issues that come up. So you may want to take a look at that and look at the requirements. As far as the requirements, the permit is really your only opportunity to get information from the companies. Highlands Ranch got a 2,500 tower proposal from Zayo. There's no reason why we cannot ask for a full 5-year plan. Let's manage this a little differently than we have, and don't rubber stamp the permits. Ask for the material, even if they aren't required to give it. Ask for the EMF specifications. ask for the testing capabilities. But today, there's no testing capabilities on the market that you or I can buy to test millimeter wave RF frequencies. It doesn't exist. The IEEE standards do not exist today. Ask them for this information. Ask them to disclose to you and us what the risks are so that you can alleviate that liability, that they are taking ownership of this particular product. As stated before, I think the faults that come up on the towers and regular testing can absolutely be asked for. Doesn't mean that they have to. Maybe there is a loophole in the FCC legalities that I didn't find. I'd love to see the text that says we cannot ask for EMF standards. They have to know it. It's their industry. We can still ask for it. We need to start speaking their language, if that makes sense. The signage is so important, especially as we disguise these towers to a tree or a light tower. Because if there is someone with electro hypersensitivity, it's a true medical diagnosis, they will have no idea that you have put a tower on their street corner, by their home, or anything like that. So signage is so important, and notification to the public is so important. Notification to residents in the surrounding areas, as well as the appeal process. If someone is not in agreement and follows, what is the appeal process? It wasn't that clear in the document that I read. It may exist, I don't know. The Chinese malware is a true issue. This technology has not proven that it is not hackable. There are cybersecurity issues out the wazoo. Chicago just rolled out the technology. It doesn't work, even as it's advertised out there. They've got unfortunate egg on their face. The companies are financially incentivized. The FCC has financially incentivized each of the companies $3 billion a year. So that's why there's a race on this equipment to land grab before people wake up and realize the problems. And I'm happy to meet with anyone offline to talk about any of these items in more detail. Thank you very much for all of your very smart questions. Very smart.
Are there any other members of the public here that would like to address the Board of County Commissioners on this topic? I will close public comment. Commissioner Holman.
Thank you, Mr. Chairman. I would move in this particular case, in the case of E19-024, Design Standards for Small Cell Facilities in the Right-of-Way. I have reviewed the staff report, including all exhibits and attachments, and have listened to the staff's presentation, and hereby move to approve the proposed amendment based upon the findings of staff report subject to the following conditions. Number one, staff will make corrections and revisions to the proposed language as directed by the county attorney prior to the incorporating the approval amendment into the infrastructure design and construction standards manual.
I'll second. Sorry.
Motion was made by Commissioner Holland and seconded by Commissioner Sharp. The chair recognizes Mr. Hill for some legal guidance.
Yeah, I just wanted to clarify. An issue came up about adding to our submittal requirements for an application for one of these small cell in the right-of-way, a engineering letter from an RF radio frequency engineer that certifies to the county that the proposed facility will comply with the applicable radio frequency emission health standards. So just that was discussed. I think it was raised during the course of the hearing.
Mr. Chairman, I have no objection to adding that as a friendly amendment.
So that would be a second condition being added to that, and Mr. Holland has.
And I will accept that as the seconder. Thank you.
Okay. Do we need to read exactly what that second condition is into the record?
I wrote it quickly, and so with just some license under that proposed language revision 30, but it will be
exactly okay.
RF engineer, radio frequency engineer, a certification letter of certification from an radio frequency engineer that the proposed small cell wireless facility will comply with applicable radio frequency emission health standards as issued by the FCC or federal government or other applicable governing body. Thank you.
Okay, so we have a motion. It's been modified.
I accept the second condition to the original motion and seek a second to include that in the requirements.
And it has been seconded by Commissioner Sharp.
And I agree to those two.
Okay. Is there any further discussion? Yeah, I believe so. Commissioner Jackson.
I wasn't sure when to say this, but I'll say it now since you asked. And that is, I'm going to support this because of the timing and the federal, to be in compliance with the federal. But I am also very concerned about the rapidity and the push that this is being rolled out, and the health and safety as well as cybersecurity concerns that has been mentioned here today and that I have read about. And so I am hoping that in implementation that we are careful with this, because once the cat is out of the bag, it's out. So, but I am going to support the motion.
Thank you, Commissioner Jackson. Commissioner Holman.
I would certainly concur with the comments of my colleague. We are faced with a very serious problem from foreign entities influencing our internet and internet infrastructure. And I certainly think it's appropriate that we, as a county, be aware of this and encourage industry and the federal government to really take these issues very seriously and ensure that the equipment that we're purchasing from overseas do not contain that type of malware or embedded electronics that copy or jeopardize the integrity of the internet itself.
Commissioner Sharp.
I just would suggest that we work with National Association of Counties to see if there's some legislation that they, representing counties across 3,000 counties across the country. This is probably something that National League of Cities would, and we're in the same building, and I think we could jointly work together with the two organizations to try to push the FCC and to do more for providing health information and data and giving more local control. So,
Commissioner Conti.
Thank you, Mr. Chair. And I wasn't that long ago that I was hearing a interview with the FCC, the head of the FCC, and you know what he was purporting in the interview was that industry, the cell industry, was the big pushers. They were the ones that were pushing, for this to happen faster and faster. So I think that there's probably enough, push coming from both sides to accept responsibility for this. And I just hope that both sides would be willing to come to the table and to work collaboratively with local governments to ensure the health, safety, and welfare of our citizens, as well as the infrastructure that everyone is desiring, and that we could work in a collaborative way.
Commissioner Holman.
One more comment I'd like to make, and I think that we as NACO and CML should be aware of this issue as well, and that is all too often in the last couple of years, we've received these expedited requests on federal and state legislative and regulatory issues, and I think we need to encourage our elected representatives in Congress to attempt to stop this expedited process and allow us who make the implementation decisions to have an opportunity to more thoroughly explore the pros and cons of these kinds of decisions. Thank you.
Thank you. Any further discussion? We have a motion and we have a second. All in favor, please signify by saying aye. Aye. Any opposed? Abstentions? Okay. Then that motion passes unanimously. Thank you all for the comment and attendance. Thank you, Mr. Fellman, for the insight, and to our staff as well. Always a good job done. Are there any commissioner comments this morning? Commissioner Holman.
I'd like to comment on the recent loss of another soldier down at Fort Carson in the war in Afghanistan. I know the state, the governor, and all in the state would like to ensure that the family receives our sympathy and understand the pain of losing a son and a husband in war. Thank you.
I have one comment, just that speaking about loss, the city of Aurora and Arapahoe County lost another young life to suicide recently. Eagle Crest High School is going through a period of mourning for one of their students who was a member of the marching band. And I just want to encourage anyone that might be watching us is that there's help out there. And if there's anyone you know that's talking about doing harm to themselves, you need to talk to an adult and to a person of responsibility that can take the matter further. And if you are contemplating doing yourself harm, you can call me. You can call your crisis hotlines. There are a number of different resources out there before you do something that drastic. So I just want to say that. Any other comments? Seeing none, we are adjourned.
So this is what they handed out here?
This is what we handed out yesterday.
Oh, yes. I'm sorry. Yes.